Hey, if you don't change your ways, you know you're going to end up spending the rest of your life in prison or jail. You understand? All right, do better.
Gilbert Quayrar stands before the court charged with deadly conduct, specifically discharging a firearm. He was already on parole, and now he's facing up to 10 years in a state penitentiary. Quayrar thinks he's ready to just move on, but the judge has a final warning that changes everything. Watch as the reality of a life behind bars finally sinks in for this repeat offender.
All right, the court is calling 2025 CR 013959-02, State versus Gilbert Quayrar. Can I have parties announced for the record?
Brandon Brader, state.
And Jonathan Alvarado for the defense.
And are you Mr. Quayrar?
Yes, ma'am.
All right, off the record for a moment. Deputy Laura, can you have them move to the other end? All right, we're back on the record. Counsel, have you received all discovery that you reviewed with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications?
Or not, Judge.
All right, Mr. Quayrar, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge be waiving the punishment enhancements, but otherwise proceeding as trial.
Any objections to the waivers?
No objection, Judge. Thank you.
You're welcome. Mr. Quayrar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with deadly conduct discharge of a firearm as a third-degree felony. Sorry, just a moment. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason that the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Quayrar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. This will run concurrent with 2019 CR 5300. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
Judge, you have to state exhibit number 1 and all back.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, just that he's ready to move on with his life. He is on parole for the case that's being run concurrent. And so he's going to go back to TDC and serve his time on both this case and that case. We just ask you follow the plea bargain.
All right, the court is finding you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. This is to run concurrent with 2019 CR 5300, and there's to be no residing in households with children. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Hey, if you don't change your ways, you know you're going to end up spending the rest of your life in prison or jail. You understand? All right, do better, okay? All right, good luck to you.
Thank you, Judge.
Quayrar.
Anyone else ready?
Yes, sir. Gonna be on page 7. Third one down.
Albert Santana.
Good morning, Judge.
Good morning. How's it going?
It's going. Happy Black History Month.
Yes, happy Black History Month. Oh, did you get our names for today? Vivian Thomas, Marie Brown, and Charles Houston. So I tell people, look it up.
Well, for me, this week is Malcolm X.
Oh, yes. I hear you. Yes.
When was it, Tuesday?
Mm-hmm. So today is plea deadline date.
Yes, Your Honor. We do have a plea offer, but we wish to remain on docket. I know that it's old and you may put us on the trial docket. We would be ready.
All right. How long is this jury trial gonna last?
A day, 2 days.
All right, Ms. Ferguson. Need a jury trial date. You can actually put this on the Wednesday because they're saying the trial will take a day, so we could do jury selection on a Wednesday morning and then have jury trial that afternoon.
I would just ask not next week, if possible.
Okay.
Give me 1 second, Judge. Let me look at some counsel's position.
The 11th.
Of March.
When is spring break?
Yeah, that's spring break.
Like, the 18th would be the next Wednesday.
We can do it on the 18th.
Can we do the 18th, Your Honor?
Sure.
Thank you.
All right, jury trial,
3/18.
March 18th.
Perfect.
All right, thank you.
Thank you, Your Honor. May we be excused after?
Yes, once he signs the reset form and once you all tender me an acknowledgement of discovery.
Yes, ma'am.
All right, thank you.
2 years in a cage for a moment of reckless violence. Gilbert Quayrar accepted his fate, but the judge's chilling warning suggests this might not be his last time in a jumpsuit. Is 2 years a fair price for deadly conduct, or was he let off too easy? Drop your verdict in the comments and subscribe for more justice served.